lord.
Yes.
So item number 18 and 19, my lord. The other case, but here number of cases, the other cases are fixed on my lord 26.
Is they not received?
18.
18 and 19. On 26.
All right. So did not receive. Please take it on 26.
I am obliged, ma'am.
Yeah, please, your lord. I beg to mention item for 33, lord.
3.
3. ED has. We may continue next.
They did not receive.
No.
If the date.
Interim, lord. Bless you.
Interim to continue.
Yeah, please. Item number 20, your lords. It is no. 2 zeros. Is there not?
All right. Same order.
20.
There is no interim, I think.
No, my lord.
Regular available. Did not receive.
Please, your lord. Next, item number 45, my lord. Yes, for open service complete after the rest. Let the matter fixed for admit.
42.
45.
45. Item 45. Submitted that service on respondent number, please.
Okay.
Please place the matter for admission on.
Bless you.
Item number 49. I was vacating. I pray for on next. Yes, the
Lordship, I for 49 petition as well. Can it be on 8th of December, your lord? This matter, senior counsel Mr. B. Datta is appearing with.
All right. All right. 8th of December.
last
Hmm?
last people no.
No, what is the difficulty? It is listed today. You want an adjournment. What is the difficulty? Yes, next.
See, intending to continue lordship in 14.
Tell him to continue.
Deeply obliged.
Lordship, item number 8 of daily list, the consent of others. Lordship, 12th of September.
All right. Prayer of learned counsel for the petitioner and the consent of. Please again now. When? 12.
I beg to mention item number 11. With consent of the others, the Lordship kindly.
Same order.
Lordship, kindly maybe after the
After?
10 of the.
Huh?
Lordship, Act 7.
Lordship, I am on behalf of responding. Lordship, it has already passed twice, so the next fixed date may be given.
Yes, give it a date.
Can pleasure.
In item number 29, plus call.
29. They did not receive. Again.
There we
Let him continue. Next.
it is
31. She was full.
Yes.
hard senior order.
30.
They're in time.
Very motor.
Inter Lordship, mention the case number, item 36.
Item
36.
36.
It is received. Pasubara Day.
Yeah.
What is it? You have received the case.
Prayer of learned counsel. Is the matter again on? CD receipt to be retained.
Lordship.
First. Thank you.
হাজবেণ্ডটো আহি পাইছে আগতে খবৰ কৰি ৰাখিব লাগে লাষ্ট মিনিটত ফাইল নাই কৰি হ'ব।
Yes, your lord.
Yes.
Petitioner, there are three petitioners were, they are in custody, my lord. What happened, my lordship will kindly see the FIR at page 8. What happened when taken place, my lord, page 16. One thief, my lord, he has tried to climb up the showroom, my lord, Havells showroom, to the adjacent one. He has climbed one tree also the process, and he fell down in the ground. After, my lord, when tried by the security person of the showroom, he was apprehended. Then number one has informed the police accordingly. This was also arrived and taken at if custody. In custody, thereafter he was taken to medical. Next day he has succumbed. He has done from the nearby scene. He has tried to jump over the Havells. Question is that page of the showroom has showed that the they has assaulted him. Lathi.
He died.
Right.
Get the CD.
Fair, man.
It is there, but the postmortem report is not there, Lordship. We need the postmortem report,
Yeah, that is the most important.
Lordship, that is why.
For a very short date.
All right. Give it it.
Lordship, on 3rd of December,
26, my lord. From Gorshuk, that is
in postmortem report, we cannot do anything, Lordship. It has to come from the,
petitioner will go from the police, then it come, my lord.
we have definitely given, Lordship. Question on 11/11, Lordship, we have given.
Then the-
26 will be too short, I think, because today is already
28, my lord. Friday.
try 28.
We will try, Lordship.
Oblige.
PM report is not received. The matter.
Listed last on 13/11, you used to call for the case diary. Wrongly listed today. Anyway, my lord, today is 56 days. Allegation of theft, my lord. Mandatory period of 60 days, my lord. You can find FIR page 12, my lord. After 13 days of the, my lord, incident, FIR was lost. FIR page 12, my lord. No, there is no petitioner has not, their name are not figured in the FIR. 56 days, my lord, on the ground of length of detention. And all these articles, LS2 have been, my lord, stolen, have already been seized, my lord.
We'll call for the CD. We have already called for CD, Lordship. It has not been come, Lordship. So give 2 or 3 days, Lordship, at least. So that I can try, Lordship, again.
CDS call for has not been received. List again on. When Wednesday,
Lordship,
Wednesday, it will be beyond 60 days, my lord.
you said 23. How many days?
Today is 56 days.
56 days.
56, my lord, yes, ma'am. You can-
Arrested on
Length of
27.
detention, ma'am.
Arrested on 27/9.
Yeah, kindly count, my, kindly count. 6 days.
Vijay,
Vijay, my lord. After, my lord, kindly say FIR itself is closed, my lord. Anti-destroy and how they, my lord, apprehend the accused, my lord. After analyzing the, my lord, cover them in CDR analysis.
where is the order of the session judge?
Session judge, my lord, did I not enclose, but I made mention in my petition, my.
Lordship, then on 25th. 25th, on 25th.
6 days, my lord.
Nedila,
After 30, my lord, kindly say
if
FIR.
we cannot provide lordship, lordship may issue.
FIR, my lord, they say after 13 days of the incident. What they said, my
Oh,
lord,
what, you are there in the CCTV, mobile tower is there, you were,
mobile tower,
it is
after 20 days.
recovered from your possession, the investigation takes time.
These are what is recovered from my position. Kindly see page 20, my lord. Page 20, my lord. Kindly see what is recovered from the petition number 1. Only 0.699 gram. He is also, my lord, Agarud dealer. Page 21, petition number 20, petition number 2. What is recovered? Only mobile phone. Page 21, my lord.
But it is 1.1 lordship on analysis of tower dump and CDR accused person. It has been observed that the accused person frequently contacted with each other.
Then, my lord, can we not
Then
talk?
it is 61 is also there, lordship.
My lord, if we talk with each other, my lord, that means that we have done something criminal activities, my lord.
And
We can
total
talk with my friends, my lord. What they says, my lord, they says after CDR analysis, it is found that petitioners are contacting with each other, staying in the same place, my lord, where an incident took place, though they are residing of different place. After 20 days, my lord,
last opportunity may be given, lordship. If on that day I cannot produce, lordship
56
may.
in the ground of land litigation, my lord, everything is recovered, my lord. 56 days. I'm taking only exemption of 3 or 4 days, my lord. 56 days. And after 13 days, my lord, had there been any incident on 13/9, they could have lost the incident immediately, FIR, immediately of the incident. After they waited 13 days, then make out a story, then lost an FIR, my lord. What they said, my lord, initially they tried to find out those, my lord, stolen properties. When they failed, they lost the FIR. And half of the, my lord, stolen things are recovered by the
even Monday.
competition.
If you had produced the order of the session judge, we would have seen it, but you said you would produce it, but you did not. That is why we are not inclined to give without the CD.
I'm not on merit, my lord. Simply on 50 days on the ground of length of detention. I'm not on merit, my lord. Not on merit. On the ground length of 56 days, everything recovered. Investigation might have been completed. Release of the petitioner would not adversely affect the investigation. Because all the other co-accused are concerned, they are released by the planet court below, my lord. Only on the, I'm not on merit, my lord. Only on length of detention, my lord. Might have been, investigation might have been thoroughly interrogated. 5 days they were in police custody, my lord.
Length of detention is not the only consideration. Monday.
Much of it.
Maybe. The second application, my petitioner was arrested on 14/9. Is 69 days and the bar. Here is this when portion is placed 10 mile. After 7 days, the LSC affair was, and she is staying in the affair, but meaning that at about 6 p.m. she went to the present petitioner for taking her Aadhaar card in his motorcycle, and when it was taken, another person it's a the affair. Yeah, my Aadhaar card was affair was lost after 7. It was 69 days. I'm married, length of detention with about 1.5 months. Under any terms condition. Both are measured. Equal is 29. Married
Yes, CD.
CD Lordship, the petition is also there. Before one is
Yes, give it date.
December 10.
Maybe. That'll be a lot. For the past days. Similarly, stated all persons have been on bail by an order of your lot. One was and paid on 40 days. They're on 44 days and they're on 48 days. Order. Same as to the last 60. Yes,
Who are you?
the culprit.
Huh?
And I'm also not there in the FIR. People. Yes. It.
What is your date of arrest?
23/9 minute. 29 to 20. It's 60 days.
There is a 90 days offense. 118. Is
Order. Yeah.
Objection.
Close the. Hmm? Oh, take middle. Yes, CD.
CD Lordship.
Name of other advocates are reflected. Are
Hmm?
strongly
You are Shakil Ahmed.
I'm A. Rahman.
Huh?
A. Rahman.
What other
but
accused?
Name of
Only,
advocate.
only one accused only. Huh?
Shakil Ahmed. Petition. Name
Huh?
of other advocates are reflected strongly in the on the last.
You are
A. Rahman.
A. Rahman. And
A. Thakur and S. Sarkar are wrongly
it is so it's A. Thakur and S. Sarkar are the present case in the cause. State name
reflected.
Krakow.
1st December. 1st December.
Bless you.
Earlier,
A report has been come, Lordship. It is found that no case is registered or pending against the petitioner, namely Saddam Diwan.
An additional PP submits on instruction received. The case has been registered. Which police station?
Sorbuk.
Huh?
Sorbuk.
Sorbog. Yes. SORPH. SAR. Against the present petitioner, Saddam Diwan. Present petition tends to
Report of report we have not found. I have not received report, Lordship.
Second time. But ours
Hmm?
is a CM court, Lordship, but there is not found against petition.
What is not found?
Nothing found.
Nothing found means
No case has been found in court, Lordship, and I have charged against petition. Even then, Lordship not providing any case for some person was sent, but police disturbing sometimes.
In this case also, we are supposed to receive a report, Lordship, regarding register of the case or not. But we have not found any report, Lordship, on 24th or 25th.
in the order it is reflected PM report.
Oh, yes. Abdul Quddus Nohai Jal.
Right.
All right, learned additional PP submits that no report as to whether any case has been registered against the petitioner has been received. Learned counsel for the petitioner submits that upon searching at the CJM court, he could not find any case.
Against the petition.
So what to do now?
Direction
What direction? In what case I'll give a direction?
only cannot be harassed. Otherwise, Lordship and any notice after Lordship and I will cooperate.
Blanket protect
How
penalty.
can we just say
Client
that?
Lordship cannot be harassed. Otherwise, I am ready.
But it is alleged that police is searching for him and harassing him. Proper OC Soigaon PS is directed to submit the report without fail by the next date fixed.
I am very clearly mentioned in para number, page number 3, Lordship. Second
Huh?
para. 11/2020 at my house also.
Okay, give on. Tuesday.
Lordship.
Whereas I will cooperate. In the
3 days, you just wait for the report.
published.
Thank you, Your Lordship. Lordship, in the interlocutory application 1146 of 2025, Lordship on the last date had issued notice and accordingly registered notice were taken on 10/11/2025, but there is a office note 17/11/2025 which says that till date neither the ID card or answer notice. However, in the main appeal, Lordship, the notice has already been served to the police. They have received it. There is a foot marked as X. The petitioner is already behind the bars for more than 1,174 days. Please admit records all. We are playing.
How many,
Lordship, till date, Lordship, it is 1,174 days.
tell us in terms of years?
It will be more than 3 years now. Evidence with here, sir, Kim has clearly stated in her cross-examination that there were no stretch mark, bruises, or any other in any parts of her private parts. No spermatozoa was seen on the fetal swipe test. When she stated the signs of sexual relations and signs of penetration, she implied that she was habitual or exposed not to recent but old signs of sexual relations. But you will find that at page 25 of the AP. There are 30. Worship at page 25, appeal, you'll find that there are 30 cross-examination, doctor, where examine the victim. There are 34, if I may read, page 25. And 35, Lord.
Era,
There are 34 and 35, page 25, Lord. Really, page 25, if I may read, Lord. 34. In her cross-examination, this witness deposed that no scratch mark, bruises, or any other injuries were seen on any parts of her body, including her private part. No spermatozoa was seen on the vaginal swab test. When she stated that signs of sexual relations seen, signs of penetration were seen, she implied that she was habitual or exposed to not recent but old signs of sexual relation. At para 35, in her reply to the court, this witness deposed that old means not recent, that is not within a week. If it is recent, there would have been signs of injury, healing, bruise, tenderness, etc. During examination, she did not find such signs. She opined that the sign was old. Victim was examined on the same day.
Lordship, since there is 10 years conviction, Lordship, we have to file written objection.
If it is an appeal of
Suspension.
that is behind bar.
no, only the IA file. IA was filed,
Highway was filed in
Highway was filed.
2025.
then,
iOS
Very recent.
so,
He's already
Yeah.
behind the bar. Long period.
but you were given an opportunity.
Whether it is Lordship, submitted,
The second.
whether objection has been submitted or not, I don't know.
Oh, no,
Then we have to.
Is the
no,
second-
only on the last date
Yes,
it was given.
present. It's 3 years, 2 months, Lordship, and 16 days.
Okay, file your objection.
Lordship. Shortly.
1 week time, Lordship. December. No,
Lordship.
10 December, Lordship.
Hmm?
10.
10 December. The prayer of learned additional PP. Seeking time to file objection. Place the matter again on 10/12.
Obliged, Lordship.
There's,
Hmm?
there's some first
For the day.
Okay.
The prayer of learned counsel for the petitioner. Is the matter. 2nd week of December.
Right. My lord. My lord.
Yes.
My lord. My lord, 145, district magistrate, Kachar, my lord, drop a under section 1. And my land has been attached under section 146 RP. Therefore, I have filed a revision petition. Is the case. And in this case, my lord, satisfy and section 165, my lord.
No, but we are now only on service of notice.
Notice private response. Name has been.
I alone.
There is a each of peace and tranquility is required. Here, my lord, in this, my lord, the lordship, kind, my lord. Their complaint, my lord. Complaint page number 11, my 11, last lines.
The impugned order is the page 17.
The translated portion, my complaint, my lord, page number 11, my. Their complaint, private person. Last 2 lines, my. Last 2 lines, my lord. Currently, I, the complainant, and my brothers residing and cannot part on Shikar, and 2 other brothers are residing at Long and Boy with their family. That means, my lord, all the family members are residing away from the disputed land. They are residing at Shillong, Big Boy, Hilchor town. So, my lord, there is no beach of threat of beach and tranquility, my lord. They themselves stated that, my lord, they are residing outside, my lord. So the question of threat of beach and tranquility in emergency situation does not arise. And this land is, my lord, my purchased land, my lord. I have annexed the deed also, my lord. Page number 30, my lord, I have annexed deed.
You have to show how the order is wrong. It may be a purchase land. 146 does not distinguish between purchased or anything. It's only a temporary measure.
Wrong, my lord. The order has been passed ex parte, my lord, the initial order, drawing of 146.
Which order is under
Page
challenge
number
here?
17, my lord.
Hmm?
Page number 17. Has been passed ex parte.
Which is the order under challenge in this petition?
Here in this, my lord, this revision, page number 25, my.
So this is second revision.
The first revision.
Hmm?
Revision.
What is criminal revision 26 of 24 before the additional session?
My lord.
Judge? Huh?
My lord.
That is the first revision.
First, the revision, my.
So this is the second revision.
This is the criminal petition, my lord.
All right. Criminal petition, you can say it is 482, but the guise of
But there is no breach of peace. Main thing is, my lord, when
don't
there is
know
a
all
breach
that.
of peace, there is a threat of peace or not, my lord. There, as per their statement, my lord, there is no breach of.
I am for the respondent, my lord. Petition, my lord, criminal petition is continued.
okay, we'll hear the matter. As it is prima facie, it doesn't appear to be maintainable.
Yes, lord.
The hard learned counsel for the petition. The hard learned counsel. Admit is the matter. Hearing on, give a date.
But in the meantime, I will file my.
In the meantime, may file, respondent may file their counter.
Hello, lord.
Right.
The state has.
Lordship, kindly pass up the adjourn the matter, Lordship. Kindly adjourn the matter, Lordship, because you don't have the record. Find the record, I am not able to find it.
I think you have filed objection.
We have filed an object. They are filing the revision by the state.
Lordship,
Against the order of the district judge allowing dimma of the vehicle. Now they
The
have.
prayer of
stay
learned
order operating.
additional PP lists the matter on
16 December.
interim order passed earlier to continue.
Lordship, there is a.
Ishari ko like, go to file that, I think.
The thing, your lordship, can it be a little bit earlier because the vehicle is, there's a stay order of the vehicle.
Then on
Police
12,
The order is in state's favor.
Yes,
then 12, Lordship. 12 December.
lordship.
Memo of file along with ILOts. I is bail.
Foxo case, Lordship.
Ulster.
Okay. Yeah, I will like. Service report to try. Complete. Complete.
Sentence is of 4 years.
Yes.
Huh?
4 years.
4.
4 years. Under section 8. Your Lordship, at the time of the incident, the incident was a minor.
Okay, we'll dispose of this. 4 years only.
But on the other, okay, Lordship, but otherwise it is POXO. Yes, otherwise it is a POXO case.
Oh, maybe.
Lordship,
Had it been so serious,
Not-
then it would have been a different section.
Lordship.
Okay. Suspense of offense. Take that out.
Kindly pass it.
Or the
Timing.
My lord, can it be on other day, my lord? I'll have file affidavit in opposition sometime.
the prayer of learned counsel for respondent number
1.
is the matter on
I see. Right.
interim order passed
Second.
earlier. Continue.
Second week. Obliged.
In the meantime, respondent may file affidavit.
Kindly pass it.
Lordship, in this case, I'm appearing.
Senior advocate Ken Soot will be appearing on legs that.
I'm appearing for the newly implemented respondents 4 to 6. I have received the copy of the 8 days back. I need time to file my reply. On 12th November, I have
Give us
received.
some time, he'll be appearing.
That it was there 12/11, you should have sought a longer date. You were
No,
there.
They did not agree. It is not possible because I have to take instruction in my client. On the last occasion, I seek 2 weeks time.
Time be appearing.
All right, let him come.
Need please, your lord. I am praying for adjournment of the expired for behalf of A Borua Lord. Maybe it fixed after 5 Lord.
What happened? Hey, Burwa?
Father-in-law expired.
The prayer of learned counsel for the petitioner is the matter. Again on.
Last fight. Last fight. Oblige you. It was that to the Jima of the cash on the last lordship last order. Place whether the amount has been kept, this custody, or it has been deposited before the trust.
I think Mr. Borwa was there.
He is coming.
All right, take up after some time.
Wait, please. It's a regular bail, my lord. Charge sheeted case, my lord. I was arrested, my lord, on 10/6/25, my lord. Today, my lord, 165 days, my lord. And my lord, charges are yet to be framed, my lord. Lordship, I have a look, my lord, at order dated 6/11/25 that has been tag marked, my lord, the LCR, my ECR, my lord.
So what happened on 15/11?
15/11, my lord, that. My lord, I have been told, my lord, on 15/11 also, my lord, charges were not framed. The charge sheet, my lord, 7 with prosecution witness.
When is the, if it is not framed on that date, then date must have been fixed.
My lord, that,
It is from here only you can find out.
my lord.
Come with the information, we'll take it up Monday or Tuesday.
Fine.
The charge sheet has already been submitted and scan copy of here is received, but it is not. Known whether charges have been framed. Necessary instructions to be obtained by learned counsel for the petitioner. Is the matter again on
25. I'm obliged.
The petitioner is behind the bar for 54 days. FIR not that is 7.
received?
Yes, my lord. Is there a receipt postmortem report, my lord?
It's M. Hash.
To pre-plan murder, my lord, sufficient materials has been collected by the.
There is a fact that Arifa Lordship is my sister, and as per allegation, Lordship, it appears that he had love affairs with the deceased. Subsequently, Lordship, what happened, Lordship? We have arranged marriage with Suhidur Rahman. And thereafter, Lordship, some conflict, Lordship, was in between Suhidur Rahman and the deceased. And the present petitioner, he has Lordship, no role in that. He is not aware in the incident. Only because he is the elder brother of Arifa, he has been implicated. If the Lordship incident is perhaps Lordship, that was the Lordship person that is Shohidur Rahman.
What is it? So what is the material?
Material, my lord, he along with Sohidur, my lord, they have killed him. They have called him at night, my lord. They took him in a vehicle, my lord, inside the vehicle. They have killed him. Then much of the dead body was thrown in a pond, my lord. And next day morning, it was recovered, my lord. And it was mobile phone, my lord. It was recovered on being dead by this accused. These are the materials, my lord. Just as I am opposing.
Mobile number belongs to
Mobile phone, handset to recover.
At the instance of the accused. On being led by accused.
On being led by accused.
Hard learned. And an additional decision application under as per the allegations. The deceased that on 26/9/25 at 11 p.m. in the night. Some unknown persons had called out the brother. That is the called out the deceased over phone. Accordingly, he went out with them, and the next day, his dead body was recovered. His father alleged that the deceased had a love affair with the sister of the accused persons, because of which the accused person, pursuant to a conspiracy, killed the deceased. Para had additional PP. A result of the PD submits that sufficient material has been collected indicating that the accused person, pursuant to a conspiracy, committed the pre-planned murder of the deceased. The mobile phone of the deceased was also recovered, being led by the accused. Para having regard to material, incriminating material available, CD, as well as the gravity of the rejected it.
My lord, we have inquired from the investigating officer, my lord. But his statement, my lord, said he, the information was, my lord, stolen gold was carrying, my lord. So their main aim was to, my lord, test the stolen gold, my lord. That has been seized, my lord. And during the, my lord, search and seizure, my lord, this amount was recovered, my lord. When the accused person was interrogated at this moment, my lord, the petitioner from whom it was seized, not this petitioner, my lord, he could not give any satisfactory reply, my lord. It is that the money was also seized, my lord, and it was deposited in the treasury. Now, lordship query was that whether the currency note number has been mentioned or not. In this respect, my lord, he has stated, my lord, this is not a trap case, my lord, that somebody has demanded money, and my lord, that money has been given. That is why in that only in that circumstances, my lord, the number of the currency note has been noted. My lord. In this case, this amount was recovered, my lord, it was seized, and it was deposited in the treasury. So this is the, my lord.
So that is his understanding.
So perhaps, my lord, whether
Only
it
in
is
trap
required-
cases it is required to be noted.
Anyway, in that case, your lordship, it is be returned back to. I have also given the judgment.
Obviously, I doesn't think it is physically required for the
Yeah.
trial.
It has been
So,
kept.
yes, my lord, when, my lord, they could not give any satisfactory reply, my lord, then, my lord, what is the source of this money, my lord? Where from they have got?
No,
That was
we are
not
looking.
mentioned, my lord.
We are looking into
Now
that.
they have come with this, my lord, with this, my lord, plea that, my lord, this amount money is belong to, my lord, this accused person, my lord, from whom, my lord, gold was seized, my lord. Secondly, lordship, another aspect to the matter, my lord. Lordship may kindly come to page number 45, my lord. The bail application. My lord, this is the affidavit, my lord, sworn by Himangsu Pal, my lord, from whose possession the money was recovered, my Now, lordship may kindly come to, my lord, paragraph number 3 of this affidavit, my
Yes.
that Sri Kishan Kanwar Kadel is a goldsmith and deals with manufacturing of jewelry. On 14/7/2023, he had requested to acquire gold testing machine from Kolkata, as I have good knowledge about the said machine and having connection with suppliers and distributors, my lord, of machineries related to gold metal and silver metal. Accordingly, he had gave me the cash amount of this so and so, my lord. Now, my lord, from the, my lord, quotation they have produced, my lord, they have annexed to the bail application. It shows that, my lord, company is from, my lord, Gujarat. So these facts are, my lord, lordship will kindly take into consideration, my lord, before disposing of this bail, my lord, criminal petition. Quotation is from Zurhat, my lord. He is saying that, my lord, this company is from Kolkata, my lord. There has to be some, my lord, link with the, my lord, statement, because this is the affidavit, my lord, he has shown, my lord, on oath. And money is seized from his possession, my lord.
Yes.
When it is seized, my lord, he could not give any explanation that this money belongs to, my lord, Kishan Kunwar Cadell, my lord.
I'd like to point out one.
So since the charge
We
sheet
are-
has been
we are-
submitted, my lord, let the trial court decide, my lord.
They have
In accordance
decided
with the law,
already decided.
let them place all the materials before the trial court, my lord, afresh, my lord.
Okay, let me point out one thing. In the order of this honorable, there is an order by this honorable court at page 65. Page 66, court specifically indicated, they have not challenged this order. They have not pointed out, came before this court modifying or for verification, for modification of this order for challenging that. At page 66, the court has specifically indicated, the court is satisfied that the money that was recovered from Pangsu Paul was actually given to buy gold testing machine. The learned court below has erroneously interpreted the acts and arrived at the incorrect finding. Now, one thing, Your Lordship, this court has been on the basis of the record that was used, same record. It is the same record because the same case, the gold and Your Lordship, money has been written. Now, in the case of gold, since we have the prayer only for the gold, the order was given only for gold. With regard to the other part, we made a submission of both of them. But since there was no prayer, that was not good. Now, Your Lordship, we have come. Now they are coming up with any. Your Lordship has already.
No, these are not new things, my lord. These are old things, my lord.
Complete.
I am, my lord, whatever I have submitted on the basis of
Record,
the materials
everything.
they have filed, my lord.
But
This is affidavit, this is their affidavit, this is not mine affidavit, my
I'm
lord.
not saying anything. What I'm saying? I'm saying that I'll give the total amount bond I'll be giving for that. It is not that. The money is now the money is nowhere, Your Lordship. Whatever money, if at all it will be required, they will come and take it from me. I'm giving the bank guarantee for that, bank bond for that. Where is the question of now? If the money is not there, where is the money? They have given it to the treasury, it has gone to somebody. There's that money is not a money trail, Your Lord. Now the question will arise, why should that money not be given to me? When I will give the.
No, it is
bond-
Sarchidat case, my lord. How can he put this question, my lord? This is a Sarchidat case, my lord. He cannot put this question
why I
at
can
this stage,
put
my
this
lord.
question, Your Lordship? Because the money has already been deposited in the treasury. Where is the question of not giving it in to the person concerned? Because ultimately the seizure and confiscation will come after the trial. Your Lord. Why it should not come? I have given already two judgments. I'll give another judgment where it says that it is bound to give the money back because that is until and yes, if and it is not been given to me for nothing. I'll give that amount. I'll give the bond. Where is the question of not giving? Now the money is not that it is a theft money or something which is kept with numbers and all, so that there will be some difficulty. Where is the question of giving it? So Your Lordship will kindly. Two judgments I have already given, and Your Lordship, this court has also referred to. And after this court, if they have so much of objection, why they didn't come and challenge this before this honorable court by the order that has been passed a long back, that is on 4/3/2025. Today they are opening their eyes.
My submission is that, my lord,
Let him, whatever his
case, my
submission
lord,
may be.
let lordship
Let me
pass
put it
necessary
in,
order in accordance with
law
my lord, merit
perspective.
of the case, my lord.
Legal
Because
perspective, I am saying.
NCR is there, my lord. Trial is going on, my lord.
What will he do with the money? Let us.
No,
let
the
me
trial
tell-
is going
let
on,
him
my
tell-
lord. He cannot put this question at this stage, my lord.
What will he do with the
Let the
money?
trial court decide, my lord. It is the
Why
trial
should
court
the
who
trial
will
court
decide.
decide
my lord.
before this matter is before this honorable court? Whereas the trial court has already
There
rejected.
has to be wrong. There has to be wrong. There has to be illegality in the trial court order rejecting Zimma, my lord.
Where is
Then
the-
only this court can
Where is the
interfere.
finding, Your Lordship?
Let him show, my lord, what is the illegality committed by
Yes,
the
I
trial.
think we have heard enough. All right.
Lordship will kindly
Good
see
reserve
the
order.
judgment at it is judgment para 60. And that earlier judgment also, Your Lordship, I have given. There are 3 judgments given. Once this
This is-
court has already held,
This is Odisha is para 60.
Lordship, Odisha is 10 and 11. And Karnataka is 6. The court has given how to hand over the money. In this case, in Karnataka, exactly the same issue, gold and money. And in the case of Orissa, the amount is also normally practically the same with the amount that is here. And all these are following this Ambalal Desai case. And in the case of Odisha, there were some other judgments have also been referred to. And in para 11, sorry, 10 and 11, it has come to a finding that has to. That is basically.
CAV.
Nobody is giving the money from their pocket.
Is in the safe custody, my lord, treasury.
Yes, that
He will
is
get
true.
the money, my lord, once the trial is over.
Yes, that is in the judgment, your lordship, para 9 of Odisha judgment. Says one, that is what it says. Currency is meant to be in circulation to felicitate trade, commerce, and overall economic growth. That is what it has, not for keeping it like this here. Obliged you.
Wait, Vijay. Lord, the Guardian Magistrate Lord did not register our case. Some weird reason has been given. If your lordship would kindly come to the impugned order at page 76.
Before that, before your appearance, learned counsel appearing for the other side said that he received the copy just a few days back, wants some more time to file objection.
It was filed on 12th.
Yeah, we
Copy
received
was served on 12th.
on 12th.
So he says he just got 7-8 days, so he needs some more time.
Let it be on Monday.
No. The instruction, the client resides in Delhi. I have sent that I need 1 week time. In the first week of December, it may be.
Monday will be too early because Saturday, Sunday are practically holidays.
Everything has been hijacked by them. I just wanted to demonstrate.
Anyway, we'll have it on a agreed date. 1 week. Next
In the
Friday.
first week,
Let it be on 25th.
no. Client has to come to sign the affidavit. In the first week, any date. first week of
Nowadays, you
December.
can send your copy today in the evening. They will get it. They will get it notarized and send it day after tomorrow. You can file it.
Everybody is not so brilliant, Mr. Chaudhary.
No, my lord. I know these people. They are capable, my lord. If I check the system.
Okay, give a date.
Next Wednesday, my lord. 25th or 26th, 27th.
or 3rd December. But and
You said 1 week. So next Friday.
Next Friday. Yes. Deep look.
Wait, please. So the regular bail application, the accused has been behind bars since 46 days. The 47 days. The FIR is at page number 15, my lord, in the operative part. I am not one of the named accused in the FIR. The named accused, my lord, have already been enlarged on bail by an order of this honorable court. I have a copy with your lordship.
15.
15, my lord. The operative part.
For the same KGMT.
Case that he received, my lord, and allegation is that, my lord, he was also present in the group, my lord, who assaulted the victim, my lord, later on who succumbed to the injuries. But the specific allegation, my lord, regarding the assault, my lord, it is not clear from.
Specific
But he was very much present in the group.
My lord, otherwise,
What was the item yesterday also? Yep.
Yesterday item was not.
my lord, otherwise the named FIR.
You have a copy of the order?
Yes, my lord.
Yes, pass that one.
Yesterday, my item number 17, my lord.
13.
EN number 3679.
Only one petitioner.
Only one, my
English. Yes.
At a earlier, your lordship had five committed suicide because of their extramarital affair. Affair, your lordship will find at page 9.
Some suicide note
Yes,
was,
suicide note
but
was-
was not found in the CD.
Not found. And moreover, it was sent for FSL lordship, whether her husband, her handwriting is it not on? Is in his, her.
Copy at least should have been there.
Oh, I have not found lordship, but in the forwarding also it is written there. Forwarding report page 18 lordship. Column numbers. Well, also 86 days. Moreover, the 183 statement of our daughter is also there, lordship. So torture is.
No, what is said in the forwarding note? There is a suicide note.
Page 18,
Huh?
column number 6.
So prosecution basically agrees that it is a case of suicide, isn't it?
Lordship. But abatement may be there, lordship.
Maybe there. But
Right, then it.
what is the evidence of abatement now? Material regarding abatement.
Case of suicide, lordship, then it is 60 days. He is in custody. Wait. They already suspended from. Considering the length of the lordship, there is.
This is under section 60 days suicide.
But 108 is there.
60.
Moreover, one thing is there, lordship. In the inquest report, it is also injury report. Inquest report is also there, lordship. The legs of the deceased.
Yeah,
were
but there
tied.
is a statement of the daughter in the CD said that since he was lying in unclothed condition openly, she closed her legs and tied it up.
That is the girl.
Girl.
Made it, not the daughter, lordship.
Ah, yes.
Girlfriend, lordship.
Mhm.
She does that, lordship. She was not found hanging, lordship. No one has saw that. She was only in the bed. Will face trial. Yeah, this I'm saying that 86 days it appears to be a case of.
Even if it is murder, you will not be able to fight because FSL is there. Hard learned counsel for the petitioner, hard learned additional PP. Is an application under para 3. One Mohammed Iqbal, second. Para. It appears from although the case is registered under section 103 and anything else?
35. Subsequently, they paid to Air Lordship 108. That your lordship will get in the order. That page 20.
I think it is typed 103 within bracket 1/3 within bracket 5 BNS. Subsequently, section 108 BNS was added. Void order dated.
That order.
So what are you referring to?
That in the rejection order, it is currently IO file.
Okay, then void order for. thereby indicating that according to the IO, this is a case of suicide. And in respect thereof, the statutory period of detention is 60 days. However, petitioner has been in custody for 86 days. And since the purported suicide note is said to be with the FSL, it does not appear likely that I would be able to file the charge sheet in the next 4 days either. Full stop. Having regard to the above, the prayer bail is allowed. It is 50,000 once you.
My objection on the ground of suicide note. Lordship. My objection on the ground of suicide note is there, Lordship.
On the ground of suicide note means?
On the ground that my objection is that, Lordship, granting him bail, Lordship, because the suicide note is there and it is clearly stated that in the suicide note that he has one woman, Lordship, with who he has relationship. Love relation.
But then 60 days.
No, that may be, Lordship.
If we record your submission, that means you are conceding it is he should be out. Is it not? All right. It is further provided that the petitioner shall cooperate with the investigation.
Fine.
Shall not try to influence or intimidate the witness. Yes.
May I please? Chief, offensive lordship, causing hard law. For this offense, lordship, I have been behind the bars last 38 years. And lordship, in this case, lordship, FIR pays lordship 8 lordship.
Yes, an injury report is there.
So, my lord, in this case, my lord, search is submitted, my lord. And my learned friend had produced one copy, my lord, on the basis of the my lord, order, my lord. The search has also been framed, my lord, on 19/11/2000.
In this case, lordship, trial has already started, lordship. TRC lordship.
Charges under?
Charges under, my lord, 126(2) and 118.
So grievous.
Grievous, my lord.
Tribal by port of the first.
126, my lord, that is a wrongful restraint, my lord. 118 is, my lord, grievous hurt caused by, my lord, causing grievous hurt, causing hurt or grievous hurt by dangerous weapon or method.
Subsection 2.
Subsection 2 is, my lord, whoever except in this case provided or by subsection or of section 120T, 122 voluntarily causes grievous hurt by any means effort in subsection 1 shall be punished with imprisonment for life or with imprisonment of either description for a term which shall not be less than 1 year, but may extend to 10 years. And it shall also liable.
Punishment starts from 1 year lordship. Tribal by court of magistrate of the first class law. Cognizance has already taken or charges have already been framed. And lordship, further is not start.
According to the FIR, injury is on the hand, not a vital part.
No, lordship.
It is
Not
also
Allegation is that attempted on the head lordship, but when it was prevented lordship, injury falls on the hands.
attempted in the head, my lord, but he restrained.
Hmm. So injury is on the hand.
Yes,
hand.
Heard learned counsel for the petitioner. This is learned additional PP decision application under so and so. It is submitted that charge sheet has already been submitted pursuant to which charges under section
126,
126 to
118.
1182 have already been framed. is further submitted that the offense is magistrate tribal. And on perusal of the FIR, appears that the injury was caused on the hand of the informant, not on any vital part. And in the meantime, the petitioners have spent how many days?
38 days.
38 days in custody. So, having regard to the above, the prayer for bail is allowed. So and so shall be. Is the 50,000 one surety. It is further provided that the petitioner shall regularly appear at the trial, shall not try to influence or intimidate the witnesses.
Eight, please, your lord. On page 8 is the FIR, your lord. Whatever, my lord, prisoner belonged to Rihabari, my lord. There was an ATM, my lord, Rihabari area, my lord. But the person went inside informant, was taking some time. So, my lord, immediately there was, my lord, some quarrel, my lord, scuffle, my lord. But he has written, yes, I tried to, his language, tried to steal money, a sum of rupees 20,000, tried, my lord. Already a month in jail. No injury, nothing, my lord. And I belong to Rihabari. But there was a scuffle. He was taking some more time. I was in a hurry. Something happened for which I deeply regret, my lord. But I am behind the bars now for almost for a month, my lord. Now.
So as part of going to the case diary lordship, one complainant tried withdrawing the cash from ATM an amount of rupees 20,000. The petitioners tried to snatch the money from him. Then the complainant ran away from the place and he hit a iron handle. Why used to shuttering open or shutter close the shutter also. And as per the eyewitnesses there, he is saying that yes, Tasul was there and he tried to snatch the money from the complainant. And then as per the injury report, lordship, the prescription committing was there and was referred to NCCT brain. And our report is complete report is not here, but the prescription is here. And he was later on he was relieved from the medical load.
You don't know what injury is caused.
Injuries caused that is not reflected in the
Once he went to the police station, he has written the FIR.
Only here, lordship, no LOC1 omitting Endor exit route and some tablets are prescribed and referred to for NCCT brain to GMCH. That is the receipt of my complete medical report not here. And then he tried to snatch the money from the victim, the informant.
That is the allegation, my lord. I never tried, my lord. The scuffle was there, my lord.
The medical report is important because
yes, lordship.
The gravity of the offense depends on that. Well,
but my there's no injury. He went to the police station. He has written the FIR.
Advice to NCCT brain.
Take also now doctor.
Case of a head injury, it is always referred.
But there was no that injury, my lord, because he went to the police and the FIR on it. And if there would have been 1 month in jail. Money also not, my lord. There is nothing to recover also. Money stolen. Belongs to Rihabari. It can no answer that.
Very hard learned counsel for the no. Is an epic. The allegation against the petition that on 22/10/25. At around 4:30 PM, last line of paragraph total. Pursuant to the lodging of the FIR, the petitioner was arrested on 23/10/25. Granted bail for the petitioner. Submit that there was a quarrel between the informant and the petitioner. The result, the informant lodged the present FIR. Further submitted, considering the length of detention 30 days, as well as the fact that there is no money to be recovered. The prayer for bail may be allowed. On the other hand, with reference to the case diary, submitted that witnesses have implicated the petitioner, the act of trying to snatch the money from the informant. The assault committed upon informant by the petitioner. However, no conclusive medical report with regard to any injury suffered by the informant is available. Regard to the period of detention, the nature of the allegation, right, there being some material against petitioner, the CD, so therefore bail is 50,000.
Your lord. Please, your lordship. Here, my lord, Krishna has, my lord, is the purchaser, my lord, he has a recipient of a slip. While he has purchased it, he is behind the bars, but there also for 1 month. He has purchased it, my lord.
One mobile phone was stolen from the hostel of a campus by Cotton University. The complaint was lost and from the going to CCTV footage, a person was arrested, Saibur Rahman. He stolen the mobile phone and he has transferred by, he sold out it to this petitioner, it does. And he's again sold it out to the other person, is Ariful. And Ariful transferred it to one person, Noor. He is yet to be arrested. So he is the person who received the stolen mobile loads.
I purchased it, my lord.
And later on, that mobile phone was recovered from one Samir Ali.
It does not appear he is any part of any ring or something. Is
stolen by another person. Stolen by another person, Saibur, and he has purchased from from Saibur Ali, and he has again sold that out to another person.
Mobile also recovered, my lord.
recovered from whom?
Recovered from another person, from Saibur, Sabiul.
Sabur Ali, I think.
Sabur Ali is the.
But in your paragraph 4, it is stated that one apprehended person, Sabur Ali, who was caught red-handed in possession of a mobile phone.
one namely Somi Ali produced one blue color Vivo Android mobile phone Vivo V2141 bearing that mobile phone was the owner of the informant. The complainant Hillsborough also present identified the said mobile phone as his own stolen property. Yes.
Now, what is the statement of the present accused this petitioner?
He purchased it from the Taibur.
Under what circumstances? Does he know
told
him or what?
Lordship, yes. February came to me and gave me one mobile phone. He told me that the phone was taken from Cotton University Hostel. So apparently he knew that it was stolen from the Cotton University Hostel. He purchased it from the Tabur Ali. Later on, he sold it to another person.
How many days? 30 days.
30.
Third learned counsel for the petition. Additional PP. An application. And it appears as per the FIR, one mobile phone belonging to the informant was stolen by some unidentified person. But on the basis of investigation, in course of investigation, one Sabur Ali was apprehended, and on the basis of his statement, it was the present, on the basis of his statement, the present petitioner was arrested. It further appears that the petitioner again sold the said mobile phone to some other person, and ultimately the same was recovered from the possession of the said person, that is Ariful Islam. Is submitted on behalf of the petitioner that he is not involved in the theft, but purchased the stolen property. In regard to the period of progress of the investigation, as well as the fact that the stolen item has been covered, further detention of the petitioner is not necessary. Therefore, bail is allowed. 50%.
PGM Kamrup Metro. Oblige your honor.
Same.
Was received. Total 45 days in custody, Your Lordship. FIR is page number, vernacular is 11, Your Lordship. Allegation, wrongful restraint and extortion. That the informant and petitioner both are business partner here.
What is this wrongful confinement?
Yes, Your Lordship, the petitioner that the person, Maqbul Hussain, the victim, and he also his statement, in victim statement here says, and demanded money 10 lakhs rupees. Give me 10, his phone call to his phone, Tom, that give me 10 lakhs rupees, otherwise I will kill your father. And when the police searched his house, then he shifted the victim to another person, another place, to help of other persons. Then police raided up, raided the vehicles at the stage. They were fled away from the place, and 2 persons were arrested at the and victim was recovered at the time. And he also admitted that yes, some business purpose there, some transaction may yet to be made by the victim and the petitioner. But he was kidnapped and extorted money, and later on he was fled away from the place. And after 28 days, from the help of local police, he was arrested from the place, another place from Dolhal in Nalbari Road. So at this stage, threatening part is there. At this stage of investigation, 45 days in custody. So this is not a fit case for granting bail at this stage. But
It's a serious offense, kidnapping
Serious
for
offense.
ransom, basically.
Other two co-accused released on bail, and victim willfully come to my
Other
house.
two co-accused means what did they do?
they shifted the person to another place with the help with the instruction on by this petitioner also.
They did not have any role in the previous part.
Not previous part. He was the victim was called by this petitioner that yes, I need some help from your side. Came to his
Where
place.
is the order granting bail? The other-
That's it.
The petitioner instructed them to shifted the person to another place. Rohanullah and my name is Zaherul Islam. As per a statement of Dr. Rohanullah, when police arrived, we shifted him from Amir's house and hide Amir's means this petitioner and hide him behind my house. We and hide him behind my house, his house. That petitioner Rohanullah. We were afraid that police will catch up and we will be in trouble. Therefore, we decided to take him to this.
To dispute.
Worship. The victim sold out the dumpers, second-hand dumpers, and the total consideration rupees is 20,85,000. Out of
Maybe a
which-
business transaction, but
that
doesn't condone what you
That
have.
might be lordship, but the
25 days
offense is serious.
custody not be- Some murder case willfully come to my house.
I think kidnapping for ransom is
Not there, you should not.
the punishment.
He has to deliver the vehicle or send back the amount. My wife also paid the victim's account worship 1,35,000 plus 34 at 35. Phone pay alert. I have
Spend some more time.
there is
Hardly.
some money transaction there in the parties.
But the
It is
fact
not a
remains that you
kidnapping,
give him.
Your Lordship, on phone call, Your Lordship, he visited my house. Your Lordship.
If you decide to solve your business problems, transactions in this manner, then be ready to be
Actually,
guest
we
of the
ready to
government.
take him to the Dipur police station, Your Lordship. At that meantime,
That is a fear of discovery. Not on the other two.
put Your Lordship.
But learned counsel for the petitioner. But
Actually, another short date may kindly.
what?
Date may kindly be next.
Yes, BB.
I'm going to case it's a serious offense and
So you file your charge sheet. He wants a date.
Lordship.
File your charge sheet in the meantime.
And then we have to send back the CD.
On the prayer of learned counsel for the petitioner, place the matter
60 days.
on after 10 days of data days.
Third or fifth years.
Third,
Third.
all right, third.
Apology.
CDB sent back and resubmitted next date.
Lordship.
Lord. This method of it already behind about 7 days. Application on the of seat alone. Here the find the FAR of 40.
What is the allegation?
Allegation that the petitioner taken the money from the victim person. The students pay the double amount of this video. And so far, FAR is concerned, it established that the victim willingly pay the amount. It a hope get the double amount. And so far, the person has already been behind the bar for 57 days as on today. Was once the criminal breach of trust, 1 of BNS sitting, stolen property 174 of BNSS, personation 19 BNSS, 5 years. So far the 112 organized crime, but so far the lesser of the case is section first. Here the allegation that the informant is the Bhutanese person. And the affair has been lost, taking that the beach of the Bhutan India Friendship Association. And the informant is not a victim.
Anybody can lodge an FIR.
I have submitted already about 7 days. It's
So the IO has collected sufficient materials, my lord, but the money, my lord, that has not been able to recover till then. And my lord, as on that, my lord, there are some other accused persons who have yet to be. That is why my investigation will be.
And he'll come after 3 days.
Let them attack about Monday then.
7 days has already been behind the bar. 7 days.
Monday will be 6 days.
Yes.
Around.
Is the government willing to
Main
pay
thing
the-
is money has not been recovered.
But
You have taken 5 lakhs, stay for
but
2
it
months
is
in
the-
jail and then you'll enjoy
my lord,
the money.
so far the willing
Okay, we'll
to
take
pay
up
the-
on Monday. Come. This matter. Yes.
Is there is
What is the matter above?
Petition is the accountant in my duty to manage the account. The duty of identify the beneficiary is the ASA workers duty, my lord, and they identify and they send it to hospital.
They verified and then they send it. My duty is to release the amount in the beneficiary's account. I can't use this for my personal use. I can't.
Yes, what is the role of the present petitioner?
My lord, present petitioner, my lord, Prolukko Deka. My lord, Prolukko Deka, my lord, he is the block accountant manager of Civil Hospital Murigaon. My lord, there is a scheme, my lord, it's called JSY, Janani Suraksha Yojana. Well, as far as scheme, my lord, the woman who delivers my lord, birth in the government hospital, they get 2100 rupees, my lord. And my lord, there is another scheme, my lord, NRC Nutrition Rehabilitation Center, my lord. Now, my lord, there is some suspicion, my lord. So, my lord, there is a
Inquiry.
my lord. So, on the basis of that inquiry, it was founded, my lord, during 23, 24, and 24, 25, several crores of rupees has been misapproved. Then, my lord, the FIR was closed, my lord. During investigation, my lord, the beneficiary who are the real beneficiary, my lord, they have not got this scheme, my lord, but other persons, my lord, who are not the actual beneficiary, they have been given by both the accused person. He is the, my lord, block account manager, my lord, and other one is the office.
Fire lot. That is fine. Have a look at number 50. That case lordship specific allegations was there in the Asar, how they are manipulating as your lordship. There was no role of the present. Because money was transferred to the directly to the account of beneficiary. There cannot be any the ASAR workers identifies the person who are depositing money. ASAR workers take out the money. It's not a case that the petitioners are in lordship. Then your lordship will find in that case the present petitioner was directed to appear before the investigating officer. Apprehending arrest, he approached before this honorable court and he was granted interim protection. That your lordship will find page 30. Page 30, that order was passed on 5/9/2025. He appeared there, he recorded his statement, and subsequently this affair was lost. And again, police called him to the police station. On bona fide belief, he went there and he was arrested. And this present affair was lost on 9/10/2025 after passing of the interim order. And both the allegations are of same. It is not a case that money was defalcated from the office. It was deposited in the account of the beneficiary, and those persons were the grassroots level. And being assistant accountant, I don't have any role. Our only duty is to disperse the money to the beneficiary's account direct. Yes. We get a list of
No,
beneficiaries and
this scheme is meant for pregnant women.
yes, that
Is it
has to
not?
be verified by the
Somebody has to verify whether
Yes,
that person is.
these are the person, my lord, who will verify, my lord.
That has to be verified by the ASA workers. They go in every house, they verify it and they submit a report to the other authority. Our duty is to only disburse the amount to the beneficiary's account directly to the beneficiary, so that it cannot be misappropriated by others.
Is there any standard operating procedure or any instructions in this regard? How it is to be verified?
That probably IO has collected lots. Because our role is to this. That therefore also I have referred to the.
Is there any
second
mention
FIR.
in the case there regarding the procedure to be adopted?
Therefore, I have referred to the second
That I
FIR.
have to look into, my lord.
Hmm?
That I have to do again. Let it come on Monday, my lord, we'll go through again. That part I have not.
Because FIRs in the second FIR which I have placed your lordship clearly says lordship that it is that woman, that is one lordship, ASHA worker, she identifies and she collects the benefits. That is the procedure.
Doubtful that only on the basis of identification by one ASHA worker, her person will be taken as the gospel truth by the government, is it?
Otherwise,
Business is so easy
no, otherwise,
without any
lordship,
verification
that
from the side of the
accounts
government.
have no role in the official work. Only related to financial work that he receives bills and accordingly disburses. That much. He cannot verify the genuineness of the claims. That superintendent is also there. He is also probably arrested in my as per my instruction. That my learned friend can say. Superintendent is also.
All right, you go through, we'll have it on Monday.
Monday, my lord.
Try to obtain instruction regarding the how the scheme works, how is it to be sanctioned.
My lord.
I doubt it, that without any role of any government official, somebody would be confirmed
No, government
as a
of-
beneficiary.
Yeah, lordship, but role of the present
No,
petitioner.
no, that is what we want to know. Maybe you have been entrusted with that role. Otherwise, despite being granted pre-arrest bail, despite you being, have you been arrested again? Is the matter on Monday? Okay. In order to enable learned additional PP to peruse the CD and obtain instructions regarding the procedure of disbursing amounts against the MSY scheme.
Yes, my lord.
journalist-
JSY.
JSY.
Yes. Better make it Tuesday, because 2 holidays are there, you'll may not be able to obtain the
My
instruction.
lord. 25th, my lord.
Please, Lord. Lordship, in this case, the petitioners it was called for law.
Is there any not received to them?
They did not receive list again on. For orders, it would enter into.
Why not 10, 12?
Lordship, interim may be
Receive.
Is there any not received? My
Then this is the 4th time.
lord, Lordship, kindly
My lord, let it come on Tuesday, my lord. Last Sunday. I take you paying for 2 more days, my lord.
What is the allegation? Because there is a clear direction to the IO.
Yes, my lord.
FIR at 9 years.
Food charge is there, my lord. Appropriation on
President,
so.
that members of this. The account is joint account, the equivalent.
Had learned counsel for the petitioner, CD as called for has not been produced for the fourth time by the IO. Learned petitioner PP prays for one last chance to produce the CD. Is the matter on Monday. In the meantime, no coercive action shall be taken against the petitioner.
25/11. Certified case there is not received, my lord.
Same CD not received. Taken on interim order passed earlier to continue. The next-
17/12. Oblige.
Received.
37 case there is not received.
Because so that there is no interim.
Yes, my lord. So, 3/12, my lord.
It would be very long.
28/11.
No.
Fifty-eight.
Received.
Case there is not received, my lord. The report has been received.
Report. CD not received list again on to and so. Interim order passed earlier to continue.
Fifteen to.
Made. As regulatory applicant for bail in accompanying appeal. Six accused persons were
What is the sentence?
sentenced 5 years or say under section 20 capital B. And I'm in custody for more than 3 years, more than half of the sentence.
All right, we'll dispose of this. It was Eric did similar order at a time.
The IO will. IO will.
I dispose.
Keep level.
Pass over the time.
Next.
Hmm?
After
Coming.
Hmm? Next week. The prayer of, you know. Give it next.
Please. Against actual lodge. And their decay has already been condoned. The appeal is also numbered. We have filed a leave application, but leave is not required because Lordship now the complainant himself has filed. He is found to be a victim by the judgment of the apex. In an NI Act case. It's also an NI Act.
So we withdraw this. We don't.
Close it.
It is submitted that
Leave application and the appeal may be.
leave
required.
application is not necessary. application for leave to prefer the appeal no longer necessary in view of the fact that the informant has
And some victim, he himself.
informant himself is the victim. Hence, in view of the above, the present LP stands closed.
Appeal may be admitted.
Appeal is admitted for hearing. Due course.
Maybe. In case they taken step by registration equal process. By register process, it was sent on 27/6, more than one already 4 months.
As per office note, ID card or unserved notice in respect of respondent number 2 and 3 does not give back. Await service. List again.
My lord, otherwise, my lord, from the postal, the postal, the can my lord confirm the tracking for which has been
Where is the postal receipt?
with the office. The office service.
No, office note does not mention postal receipt.
But my lord, it says that they have taken steps sent by this person. So the postal receipt must be in the office.
So the postal receipt?
Be in the
No, you can take it. It may have taken steps by registered post, but ID card is not back.
But my lord, the post maybe
What will you do with that?
my lord, it can be traced with the postal website of postal department. Whether it has
You
been
can do that yourself.
I am not having the post.
Huh?
The post, I am not having the post, otherwise I can check. Can be saved by the office of the
It right registry to obtain. What is that called? Consignment
tracking report.
Huh?
Postal tracking report.
Postal tracking report tracking. List again on. You had to take steps to concerned police station.
We have not received any instruction.
Fine.
Huh?
Ask. Get the give the
There are two such orders. So you have to obtain the instructions. What is the process by which you?
It was routed through registry lodge. Registry give us the notice, then we sent it to the IO. And they usually lordship, when it is completed, they give us a service report
No,
lordship.
in this case, you must have received it from the registry.
But I need to look into that, whether it has been sent from the office or not. Whether it has been received from the registry or not, I also don't know about that lot.
When will you find out?
Not on 27.
Only for that you need so much time.
No, Lordship, if I will ask them to serve it, if they have not served it, Lordship, that is for that reason.
PP submits that he has not received any information regarding service of notice from the concerned police station, and it is to be inquired whether thus requisition has been sent from his office placed for some time to complete the process. Accordingly, list the matter again on 20.
Obliged.
May I please? Yes, Lordship. Committed clear Lordship. I owe this case strong section Lordship. Apparently, Lordship, and I have the college certificate Lordship. But the kindly come to for moment Lord, page number 24 Lord. Page section 4 of POXO is added. There Lordship, but it did not come Lord. Without any case proof documents Lordship collected by the IO Lordship. Even then Lordship government is really silent about the age of the Lordship.
This is also same. Additional PP takes time in order to obtain instruction regarding service of notice upon respondent number 2 from OC Chhoigaon. There has to be a process pursuant to an order of the court. We should have the instruction on the next date. The day the case is listed, you should be at least ready with the information whether your part of the job has been done or not. And an additional P submits that no instruction is available with him. The moment. You first find out from your office.
Lordship, I will.
Is the matter again on Monday.
Obliged, deeply obliged.
Madam, maybe
Hmm?
senior is legal in put number 9.
What is it about? All right, call the next item.
Was convicted under 304B IPC for 10 years. And as on total lordship, he was in custody for 2 years, 11 months and 15 days. Her allegation is lordship, her father alleged that appellant demanded 50,000 rupees as dowry and tortured and threatened to kill her. In the postmortem report, lordship, opinion is asphyxia due to antemortem title in this prior lordship, 4 months prior at their test.
Moreover, Lordship, there is a respondent number 2 is also. It is.
But no name is shown.
This one. Not sure.
Name not shown in the call.
Lordship, that is why, Lordship.
Lordship, Lordship,
But they have implicated, Lordship. Only.
in
So in criminal appeal, it
But anyway, you have implemented them and they have been served, but their name is not shown.
consider only
So,
2 years, 11 months.
no, whatever, but
Five weeks occasion Lordship was listed, but
when their name is not shown, how can we just
cannot have it.
proceed?
IO admitted that no direct evidence dowry demand was.
In the IA, they have not implemented, I think. What is the provision? Only in POXO?
Only in POXO, Lord. In the IA Lordship, only state is paid party.
Criminal appeal, Lordship, that is different. In POXO, it is, the Nayak case, Lordship, it is only for POXO.
Yeah.
But in this appeal, criminal appeal, Lordship, in these cases, that need to be hard, Lordship. Okay. Better break. POXO case sobotey lagibo. In the bail also, in everywhere. That is different. You cannot compare it with
High Court notice. Lordship may take it to Lordship. In the meantime, I will place where it is stated that.
But you have implicated, no? Then if you know that, then why you have implicated as respondent number?
No, in IA, there is no response. Only one state is.
And their name.
All right, we'll take it to you, get the notification.
Deeply obliged.
And appears, list the matter of 2 weeks.
Here, what has happened? Here, basically, an FIR was registered long back. Now, that FIR, the allegation in the FIR was the same allegation in the departmental proceeding. In the departmental proceeding, the informant, he denied to give any evidence. With denying to give any evidence, he files an FIR. We challenge this by filing a criminal petition before this honorable. This honorable court stays the entire investigation. What they do now, after about 4 years, when the investigation is stayed by this honorable court, they files a charge sheet. And this honorable court was asked for an instruction from the IO as to why it has been done. S1 number 2 is just a formal party. They are informant. They have got nothing to do with it. We have served a copy upon them. So, Your Honor, Lordship, this matter is fixed on 25 before the court below. To say that the stay which is operating it continued, because till date the stay has not been vacated.
And that is for the court below to consider then if the stay is already in existence.
Court below has passed an order till 25. It should be in abeyance in line of the order passed by this honorable court. In this regard, I have filed an affidavit, but the affidavit. Can it come out on 25 then? Not the affidavit.
It is submitted that an affidavit has been submitted, which is on behalf of the petitioner, which is not on record registry, to trace out the same and place it on record. Is the matter again? Date? I don't think we can.
Because otherwise, Lordship, what will happen? In spite of a stay order by this honorable court,
The court below will proceed against me, Lord.
Now, is the stay ordered for a specific period?
No, Lordship. It was not for a specific period till disposal of the criminal petition, and that
You have the order. You have the order passed by the court.
I have already annexed this order.
No, let us see. Is the order?
That is still the next date of listing. Page number 15, Lordship.
Is it by the court below?
No, by the Honorable High Court, Lord.
Yes.
It
To
was
state till the next date of listing.
It was listed, Lordship, on 20. Last it was listed.
So it was for a specific period. It was not an omnibus order.
No, it was not an omnibus order, Lordship. Considering everything,
What is wrong with the magistrate's order?
Lordship, the order was passed on 25/1/2021. After this matter has not been listed till date.
It was your responsibility to get it listed.
But Lordship, respondent has not filed an affidavit till date, Lord. Respondent too, knowing very well, he is the sanctioning authority. Knowing well, he has not filed
You
any.
may not be bothered. You are supposed to protect your stay order.
I would pray, Lordship, if let it come up on 25, then let the stay order. Let the stay order be extended.
You have not gone into it. You said that we get the affidavit.
Let it on 25.
It's for 25.
I'm deeply obliged. Lordship, I'm very sorry. I missed up a supplementary item number 58. I was in legs in foot number 3, Lordship. 58, a report was supposed to call for, Lordship.
We are not going back there if we have passed orders. Yes, next item.
May I please, Your Lordship? Your Lordship, I filed this IA for rectification of the cause title, incorporating the correct name and address of the respondent number to the main criminal petition, Your Lordship.
This has been preferred in correction of the name of the petitioner number, respondent number.
Respondent number 2, Your Lordship.
Respondent number 2 in the first title of connected appeal. There is the record.
Your Lordship may allow me to file an amended cause title and take the steps accordingly, Your Lordship.
Which is the correct address?
Your
now?
Lordship, the second one is the correct. The first one, Your Lordship, is the mistake. Anindita Bishwashi, the title is wrong, Your Lordship. Should have been Hazarika, and the address is, Your Lordship, different address. According to the FIR, Your Lordship.
Name of the respondent number to be corrected as 3 phase 3 Anindita. Anindita. Phase 3 corrected as an address Gurehin TDB. File application.
Your Lordship, if the order it is not reflected as amended cause title, they will not take up amended cause title. Lordship, filing petition.
We'll say that will be read as the Anindita Hazarika.
Yes, yes.
In the first title of the connected appeal.
But Your Lordship, if the word cause title is not there,
Yes,
appropriate
cost title will be
application.
there. The cost title of the connected appeal. Cost connected. Is to the new. What more is required?
Your Lordship, and I will take the steps. A new address.
Yes. Steps.
Obliged, Your Lord.
Disposed of.
case, while on last page, was pleased to call for the TCR lordship. The TCR of the trial court has been received, but the TCR of the state court lordship, which order has been still here, that was not received. Call for lordship.
What has not been received?
The teacher of the appellate court, teacher of the miss case number 31 oblique.
That is received.
That was not received. That order has been assailed here, Lord. The documents from the petition, the annexes are to appellate court. Here of complaint case number 3253 has been.
It appears from the office note dated 19/11/25 that the scanned copy of the PCR of CR case number 3253 of 21 has been received from the CJM Kamrup Metro. However, record of is case number 31 of 24
From the court of justice,
yes, from the court of the additional passengers FTC. Three Kamrup yet to be received. Hence is them again on registry to issue reminder.
It may be fixed to law.
Give it-
It's 8
Can it be on
December.
8th of
8 December.
Any interim order is there?
Yes, interim order.
Interim order passed.
Deeply obliged.
Obliged.
Time.
My lord, as per order dated 10/6/2025, lordship, my lord, the interim prayer may be considered lordship. After the case diary, LCR lordship, on the last occasion, my lord, was, my lord, had not gone through the, my lord, case record, that is why my time was limited. But text of the case, lordship, the petitioner is a, my lord, co-graduate law. While, my lord, prosecuting studies in my lord, NEF law college, my lord, the informant, my lord, was also a student, lordship. They had love affairs, my lord. Ultimately, both the girl fled here from the home, lordship, and from Mary's lordship, by my lord, conversion, lordship. The converted lordship and Mary's was registered, lordship. Thereafter, for some days, they were residing in a, my lord, rented home, lordship. But the petitioner, lordship, husband, my lord, earns nothing, lordship, and she, my lord, gets more than 20,000, 28,000, my lord, a handsome salary by doing job in a company, lordship. Then a relation, my lord, was distant, lordship. She was missing from home. She left the rented home, lordship. Thereafter, the petitioner lost FIR, missing information, lordship. My lord, after losing missing information, lordship, actually she did not want to, my lord, live with him, lordship. She lost an FIR, lordship, before the police station, lordship, with allegation of, my lord, extortion, lordship, physical assault, lordship, my lord, trying to change her identity, etc., lordship. Now, kindly see the charge sheet, lordship, at page 93. Charge sheet is challenged. At page 93, charge sheet is there. During investigation, police, my lord, did not find any witness against the petitioner. It is specifically mentioned, lordship. 93 is the charge sheet, lordship. The column, witness column, my lord, at page 94, this is nil. My lord, now
page 98, Lordship, during investigation. Lordship, page 98, got it. Charge sheet, Lordship, and type copy, translated copy.
Yes.
During the investigation, second paragraph. During the investigation, the place of occurrence was visited and its case map was drawn. No witness was found against Said Akib Ahmed at the place of occurrence. The victim was questioned and her statement was recorded in connection with the case when it was intended to get her health examined by the doctor. She refused for medical examination. Notice under section 35(3) BNSS was issued to Akib Ahmed and he appeared at the police station with an order of interim period bail passed by the Honorable High Court. He was questioned in connection with the case and was released on bail as per order of the Honorable High Court. His father Abdul Khalik took him on bail. The bail bond has been tagged with the case diary since a well-established case of committing offense under section so and so has been found. Have submitted charge sheet to the Honorable Court in consultation with the officer in charge of the police station, my lord. No witnesses there, my lord, the case is established. This is a case, my lord, how the case will be proved, my lord, against the, my lord, lordship. This FIR was lodged just to, my lord, create a, my lord, make a ground of divorce, lordship. There subsequently divorce petition was filed, lordship, by her. My lord, the petitioner also filed, my lord, a petition for restriction of conjugal right, lordship. He has also filed, my lord, maintenance case, DBA Act, my lord, case is also has also been filed, lordship. Now her intention is that, my lord, let her leave, lordship. My lord, allegation of my lord, allegation of my lord, trying to get her, my lord, identity changed, lordship. Now she herself has changed her identity. Kindly see divorce petition, lord, at page 70. Page 76, lordship. My lord, 77, divorce petition. Oh, extension, my husband and wife, my lord, extension now, my lord, this, my lord, will be an offense, lordship. Cited in the same mess. She did not offer for medical examination. Used. My lord, how the assault, medical assault will be proved, lordship. No witness is here. On the basis of vague allegations, my lord, the charge sheet was submitted, lordship.
Yes, prosecution.
I want to state here, lordship. And this is a quashing petition, lordship. And moreover, I have also seen that there are the title suit is also there.
Right to
Title, there are many things are there, lordship. It is not only lordship that
We'll have to examine finally.
lordship, it is better, lordship, if opposite party, lordship. Number 2 also appear, lordship. Because it is not only that,
Made a party.
various angles are there, lordship.
Made a party.
Lordship. They have made a party, lordship. They have made a party,
The party, lordship was issued, lordship. Till then, my lord, maybe further proceeding may be state,
Because
lordship,
no,
otherwise
lordship,
cognizance will be
without-
taken, lordship.
When was notice issued?
On 10/6, lordship.
Notice was issued on the date address given in the my lord divorce petition lordship. Kindly see page 77, my lord. Page 77, my lord, divorce petition application under section 2(1) and 2(7)(a) of the Resolution of Muslim Marriage Act, my lord. Where is my lord? The attempt to change her identity. He herself changed her identity. He had become my lord, she had converted, and the application was filed at Muhammad Law Lordship. Can you have a dignity examine and finally hearing, my lord? Till then, my lord, maybe paid lordship. My lord, her intention is to, my lord, leave, my lord, avoid the petition. She wants, my lord, to settle her
one
own
more-
life.
The office note about this service, how long?
Office note of, my lord, it was service not complete. Lordship.
Not complete.
Address is them, lordship. Address in the same time given by herself, lordship. In the divorce petition, lordship.
Remark is insufficient address.
My lord, well, that is given in the divorce page 2077. Her address high here. Anyway, I'm
Yes,
asking,
it is a comprehensive address. How can it's insufficient?
my lord, unless the proceeding is state, my lord, notice may go, lordship, proceeding may be state till then, my lord. Till the next date, my lord, may be state law.
What is happening in the divorce case?
Divorce case, my lord, that is in the WS, at the stage of WS lordship. WS was filed by the husband lordship.
So you take dusty service there the next day.
Until next date, my lord, may be state law. Otherwise, my lord,
What
will
is-
not be state, my
No,
lord.
lordship,
He cannot
after,
apply for, my lord.
What is going on now in the trial?
He cannot apply for my
What is happening at the trial?
trial, my lord. Cognizance, my lord. Just listen. Not yet taken lordship.
And what is there to be stayed
My lord,
till the next date?
cognizance be taken lordship.
Cognizance notice by that time we'll have it.
My lord, lordship, Honorable could observe, my lord, after receiving health credit. Finally, my lord, on the day of motion, my lord, the if found fit or pay, my lord, the order is passed. Now, here has lordship, lordship also.
justice service may be directed to justice service.
Witnesses are not there, lordship. Sir, my lord, family dispute is here, lordship, but criminal,
Already heard learned counsel for the petitioner. Heard 50. Here's the. Please, the respondent number 2 is it is directed justice service. Effect justice service upon the respondent number. Should we mention at the family court?
my lord. Lord, I will try, lordship.
We'll say in the family court, if it is mentioned in the order, it will be better for you. Which family court is this? The court of the principal judge, family court number.
Court number 6, lordship.
Six. There are 6 family courts.
Kamrup. Family court number 6, lordship.
This is Kamrup Metro.
Any lordship, family court may be.
Right. Just
Date is on 19th of
the next date fixed, that is 19
December law.
in December. In FC civil number 1493 of 2024. Is the matter again on given date in January. Till then, further proceedings pursuant to charge sheet number H3 of 2020. Pertaining this special dated T. Be kept in a
What's up like that?
I believe. You are have come with the instruction.
Lordship.
Yes, but
Lordship, may I place this information? You may peruse notice dated 21/12, second para, Lord. Shall be obligatory. Shall be obligatory for the appellants with the incident victims or accused person, as the case may be, the appeals filed under 370 or under 690. So one petition filed under. Thereafter, Lord, after Deepak Nayak judgment, there was another notification. Numbers
your application is
389.
Huh?
389. Appeal of 374. Appeal of 374. 370. Lordship may peruse the next petition after the precipitated. Lordship, application dated 15/3 the Honorable Justice has been pleased to adopt the following direction for proceeding criminal appeals division or criminal petition filed under the POCSO Act in the Guwahati High Court and outlying. There are specific mentions of criminal appeal. Your Lordship, the appellant convicted under 4B. Point number C, Lordship, in every bail application, criminal appeal, criminal revision, criminal petition arising from cases involving offences under POCSO Act. First para, Lord, specifically stated that filed under POCSO Act.
so this is regarding POCSO only
Lordship, POCSO
and 376.
Lordship. 376 involved in the minor law. Those Lordship 376 and 376 BB 20 subsection 3 law.
What other provision is there? You are saying this is only for POCSO. Right? Is there any other provision?
Good judgment.
Yes, there is some notification, we cannot just say. But he may want to implement, that's a different matter.
But statutory law.
Yes, what is this about now?
Round I place Lordship only 3 para.
judgment. Paragraph 51 and 57. Kindly pay
Your sentence is how much?
10 years. And as on today, Lordship, 2 years, 11 months, 15 days.
However, in this case, I can only state that, Lordship, it is within 7 years of marriage, Lordship. And moreover, in PWA, Lordship, he has, that is the father, he has specifically stated that there is a demand of 50,000 from his daughter, asking her to brought it from him, Lordship, from the father. And in corroboration, Lordship, PW 2, 3, 4, other family members were also there, Lordship.
3, 4, and 5. Lordship, I kindly peruse the 3 paragraph. Will clear, Lord. There are, Lordship, in appeal memo, Lordship, para 11, Lordship, page, para 27. Kindly see. Para 26. Start from para 25.
26 of?
Lordship.
But this,
Appeal memo, Lord.
but it is already rejected earlier.
May I place, Lordship, one judgment, Lord? Next.
How can we then reopen it now?
Only, Lordship, length of detention. If I peruse the Lordship, para, Lordship, kindly see, Lordship, para 21. Lord. Para 21 of judgment, Lordship.
Judgment you have annexed.
Lordship, annexed in the appeal memo, Lord. Kindly see.
Not in the IA.
No, Lordship, in the appeal memo.
Should annex in the IA also. Otherwise, we have to go here and there all the time. Yes.
Page 26. In court line, Lordship, according to him, Lordship, Dr. Lordship, according to him, the death was due to asphyxia resulting from anti-mortem hanging. It was suicidal in nature. And Lordship, in para 22, in cross-examination, PW6 has quite categorically stated that no any kind of wound was detected in the body. The dead body was suicidal in nature. Nobody had killed the dead body prior to its death. And para, Lordship, then Lordship, paragraph 27, Lordship. IO, Lord, 27, para 27. In cross-examination.
Para 27 of judgment.
Lordship, judgment. Para 27 of judgment. In cross-examination, PW8 IO has stated that he had not recorded the statement of scribe. During investigation, he did not find any evidence that deceased and appellant had previous strenuous relation. They had love marriage, but the family member of the deceased did not accept the marriage. The affair was lost after 3 days as because the informant was mentally down. And in last portion, Lordship, in last 4-5 lines, during investigation, he had not found any evidence to show that appellant demanded dowry from the deceased or from her parent. And Lordship, neighboring witness, Lordship, PW 3, 4, 5 said that, Lordship, the marriage appeared peaceful and there is no dispute, Lordship, or quarrel, Lordship, never of any.
In page 44 also, para 42. IO has also supported, Lordship got it, 44 Lordship, para 42. The IO has also supported the fact accused by PW 1, 2, and 7 that accused number, Lordship, A1 used to demand, accused number 1 used to demand money from the deceased, but there is a gray area as regard the exact money of it is only that, Lordship. But the demand is there.
What is the meaning of IO supported?
Lordship, he has in his examination, Lordship. In the morning also there is a quarrel between A1 and D over some domestic issues, Lordship, in the morning itself.
Issue, but not connection. Lordship. Based on judgment law. Second page, their lordship was convicted for 10 years. That was period of, in our case, 2 years. Trial law.
But if I look into page 41, lordship, there is stated that according to PW1, page 42, lordship, above paragraph, the first paragraph, according to PW1, that is the father of the deceased, after 1 month of his daughter's marriage with accused number 1, the latter had demanded rupees 50,000 from his daughter, asking her to brought it from him. And in this regard, his daughter was physically tortured. And this is also in PW2, lordship, in same page 42. PW2 was the uncle of the deceased, and he has also corroborated the fact that on the day of occurrence, PW1 had asked him to go to the house of the accused as his daughter had died. He has, however, stated that the accused used to demand money ranging from 10,000 to 20,000, lordship. So specific amount is there, lordship. On the PW1 has stated there is 50,000 was demanded. Very specific.
In our case, no act of cruelty law or harassment of public.
However,
The general allegation.
in the judgment, what I have seen, lordship, court has also taken the help of 113B of the Evidence Act. Stress on more that, lordship.
And 30, I just say when the cruelty or harassment in connection with dowry link.
But from the judgment, what I have seen, lordship, PW 142. It has been, I have already read out, lordship. According to father of the deceased, after 1 month of his later had demanded rupees 50,000. So he has stated that not specific amount is not there, but it is there. And uncle also stated that same thing.
These are final points. We not go into all the.
Lordship. Otherwise, I leave it to lordship law.
Length of detention. Most
Leave it to lordship.
Yeah, it is of 2050 law.
Third learned counsel for the petitioner. This IA has been preferred taking suspension of sentence and grant of bail to the appellant. Applicant has been sentenced to undergo 10 years RI. Account of his conviction under section 304B
and 30.
and 306. IPC. By the learned additional session judge Borpeta. Some by the impugned judgment sentence dated see from the cost.
6/12.
Pastin. Para. Council has pointed out 13 purported flaws, impugned judgment. and has submitted that the petition has already spent how many? 2 years,
2 years, 11 months, 15 days.
2 years,
As on
11 months, 15 days as of today in custody, and he was on bail throughout the trial. There appears learned counsel for the prisoner has relied upon decision of the decision of the Honorable Supreme Court in Kartik Pandit versus State of Jharkhand in criminal appeal number 1445 -1446 2025 dated 24/3/25, whereby the Honorable Apex Court had granted the benefit of suspension of sentence and bail to the appellant who was sentenced to undergo 10 years RI and undergone incarceration for a period of 2 years and was also on bail during the course of the trial. It is well settled that having regard to the facts and circumstances, it is within the power of the High Court to suspend the sentence of a fixed period, even though the appellant may not have undergone half of the sentence. Going through the record, I'm of the view that this is a case for suspension and bail to the accused. Accordingly, the impugned has sentence imposed by the dated pencil to review. On which date was the sentence? Same day.
6/12.
6/12. But 24.
22, Lordship.
22.
Lordship. Page 57.
In sessions case number 91 of 22. By the additional sessions. Which place?
Orbita, Lord.
Orbita.
Additional passengers.
Will remain suspended. The petitioner shall be released on bail of rupees 50,000 with 2 sureties of like amount to the satisfaction of the learned said learned court. I stands disposed of. Is the appeal in due course.
Deputy of Law. Hey, please. But at the morning, I have mentioned for item number 20 alerts for the city alert. So the next date will fixed on 5th January. I have seen online. So what date may be?
Regular bill.
Yes, my lord. Regular.
5th January.
Huh? I have seen. Why would
That will be very long. Since
5 February? I left 3 times per
5/12 করে দিলে
5 Highly mass.
অল জাজমেণ্টটো থাকিল নহয় হেৰিটো অহা নাছিলে ন ৰাতিপুৱা সেয়া প্ৰেজেণ্টেশ্যন ইয়ালৈ অহা নাই নেকি? বিল নাই নহয়? হ'ল না? In the aforesaid view of the matter, I deem it fit to dispose of the instant application with the following directions. One, if the revision petitioner is agreeable to providing a suitable alternative residential accommodation, then the respondent shall vacate the house of the petitioner, go to the alternative accommodation. Alternatively, the respondent may herself choose a similar alternative accommodation herein, rent for which shall be payable by the petitioner. In case the revision petitioner is not agreeable to any of the two aforesaid arrangements, the respondent wife and the child shall be allowed to reside in the shared household, that is the house of the petitioner, and in such circumstance, He is directed to restore water and electricity supply to the part of the residents in possession of the respondent. In terms of the aforesaid directions, the revision petition stands